Utah Code Annotated, Section 61-2, is the section of Utah law which contains the laws which establish the real estate licensing procedure in the state of Utah. The legislature has the authority to enact laws to protect the interest of the public. Since real estate transactions are typically a large and important transaction for most individuals, the government feels regulation is necessary. The statute begins by stating that it is unlawful for any individual to act as a real estate broker, associate broker, or sales agent in the state of Utah or with respect to a property located within the state of Utah without a real estate license. Specifically, the statute states that one may not engage in the business, act in the capacity of, advertise, or assume to act as a principal broker, associate broker, or sales agent. Utah Code Annotated 61-2-1. The real substance of the statute comes in the definition of engaging in the business of a licensee. It is important to note that the statute is very specific regarding those practicing real estate outside the state of Utah. If an individual or company is dealing with a property in Utah, the transaction still falls under the jurisdiction of the Utah statute, regardless of the location of the individual or company. The business of real estate. The statute contains a lengthy, multi-part definition of what actually constitutes acting as a principal broker, associate broker, or sales agent. The definition is the same for all three license types. We will break the definition down into individual pieces. Any individual who sells or lists for sale, buys, exchange, or auctions real estate, options on real estate, or improvements on real estate with the expectation of receiving valuable consideration is, by statute, participating in the business of real estate. The statute continues by stating that the business of real estate includes advertising, offering, or attempting to be engaged in the business of real estate according to the definitions we discussed. Again, let's break it down further. Traditionally, real estate agents are compensated on a commission basis. Perhaps for this reason, some think that if an individual is paid salary rather than commission, they do not need to be licensed. For example, let's assume a builder wants to hire an individual to market the homes in a subdivision being developed by the builder. The builder does not want to pay commissions, so he hires an individual to market and sell the properties. The builder pays the individual a salary. Does the individual need to have a real estate license? The answer is yes. We will discuss a few exceptions later, but the simple answer is that the method of compensation is irrelevant. If an individual performs any of the actions we have discussed as part of the business of real estate, they generally require a license. Please note, the fact that an individual is an employee of the owner of the property generally does not make a difference. Again, it comes down to what the individual is doing. If they are performing any of the functions we've discussed, Utah real estate law applies. Property management. In Utah, property management functions are included in the business of real estate according to the statute. Property management is defined as engaging in, with the expectation of receiving valuable consideration, the management of property owned by another person by performing any of the following functions: advertising for, arranging, negotiating, offering, or otherwise attempting or participating in a transaction calculated to secure the rental or leasing of real estate, collecting, agreeing, offering, or otherwise attempting to collect rent for real estate and accounting for and dispersing the monies collected, authorizing expenditures for repairs to real estate. Property management, according to the statute, specifically does not include hotel management, tourist accommodation management, or mineral rights management. Tourist accommodations include any property rented for a period of less than 30 consecutive days. A couple of points covered in the definition of property management warrant emphasis. First, please note, again, the statute requires compensation to be part of the equation in order for the statute to apply. Theoretically, if an individual wants to perform property management functions for absolutely no compensation, they would not be covered by licensing law. However, the compensation does not need to be money in order to be considered compensation according to the statute. The statute is very specific in stating that compensation is anything of value. Second, the statute specifically states it applies to those engaging in property management functions on property owned by others. If an individual owns a property, they may perform property management functions on their own property without a license. The statute also states a license is required if an individual or company advertises or holds itself out as a property management company. Advertising without a license, even before performing any property management functions, is a violation of Utah law.